It all started with a ramp. Just a simple wooden ramp on the front porch, built so my daughter, Riley, could get her wheelchair up and into our house without me or my husband having to carry her every time. It wasn't fancy. We didn't pave over our lawn or install neon lights. Just a clean, sturdy ramp, safe, weather-treated, and necessary. But that ramp, innocent and essential as it was, would become the opening shot in a war we never wanted. We moved into the neighborhood 3 years ago. It was one of those master-plan communities, with glossy brochures and photo-ready parks. A gated suburban oasis, they said. Somewhere to settle, raise a family, and feel safe. That word, safe, felt heavy on our shoulders since Riley's accident. She'd been 9 when a drunk driver blew through a stop sign, shattering her spine and our hearts in one blink of a second. After months in hospitals, rehab, and endless therapy, she came home changed, but no less vibrant, brave, or full of life. We bought the house because of its accessibility promise. They had a clause in their community guidelines about accommodation for disabled residents. It was supposed to be a welcoming place. Turns out, paper promises mean nothing when people like Karen Delling are in charge. Karen wasn't just on the HOA board, she was the board. President, treasurer, enforcer, dictator. Her official job title might have been Homeowners Association president, but her real passion was petty tyranny. From the moment we moved in, she gave us the kind of smile that hides a knife behind the teeth. Tight, judgmental, condescending. Our welcome basket was filled with printed HOA bylaws instead of cookies. On day 2, we got a warning letter because our moving truck obstructed neighborhood flow. On day 4, she knocked on our door and told us our blue flower pots weren't in harmony with the colonial aesthetic. On day 10, she asked me if Riley's equipment would be a permanent presence in shared spaces. I tried to be diplomatic. I reminded her of the community accessibility clause. She shrugged and said, "That doesn't mean you can install ugly ramps that lower property values." Let me tell you about that ramp again. My husband, a carpenter, had built it to code. He even painted it a soft beige to match the siding. But to Karen, it was a symbol of rebellion, of non-compliance. She cited us, repeatedly, claimed it violated setback rules, even though it didn't extend past the porch. We appealed. The HOA lawyer agreed we were within legal rights. Karen filed a personal complaint anyway, calling it visual pollution. And that was just the beginning. Every week a new notice. The mailbox wasn't up to uniform spec. Our trash bin sat out for 20 minutes too long. Riley's specialized wheelchair-accessible van violated driveway width allowances. When we tried to build a small pergola so Riley could sit outside in the shade. Denied. Unapproved structure. Then came the meetings. Oh, the meetings? Karen ran them like a courtroom drama starring herself. No microphones. No record. Just her, a gavel, and her loyal band of neighborhood followers. Mostly retirees with too much time and too little empathy. I spoke up once. She cut me off. Said, "The board has heard enough from you." When I showed photos of Riley struggling without the ramp, Karen rolled her eyes and muttered, "Emotional manipulation." I started recording every interaction. I began documenting every letter, every warning, every sarcastic suggestion from Karen. And I wasn't alone. Quietly, neighbors started whispering stories of their own, of Karen stalking their lawns with measuring tape, of her shaming a family for letting their autistic son draw chalk art on the sidewalk. But no one wanted to confront her. Why? Because Karen fought dirty. You challenged her, she'd find your code violations. She'd fine you. She'd call zoning. She'd get you audited if she had the chance. Things boiled over on a hot Tuesday afternoon. I was working in the garage, Riley beside me in her chair, helping me paint flower boxes. We were laughing, music playing. Then I heard the unmistakable click of a phone camera. Karen was standing on the sidewalk, snapping photos. "What are you doing?" I asked, stepping out. She didn't even flinch. "Documenting violations." I walked to the edge of the driveway. "You're photographing my disabled daughter." "She's on community property," Karen said, as if Riley was a wild animal crossing her precious land. "Your noise levels are excessive. This is grounds for citation." I snapped. I told her to leave. I told her she had no right to stalk my family. Karen smirked and said, "I'll leave when the board decides you're fit to live here." 2 days later, we received a formal HOA lawsuit. Karen was suing us on behalf of the HOA, accusing us of lowering the visual standard of the community, of unauthorized construction, and of aggressive conduct toward board members. She demanded that the ramp be removed, the van be moved off-site, and we pay $25,000 in damages for emotional distress and reputational harm to the community. My hands trembled reading the papers. Riley asked me what was wrong. I didn't have the words. I just hugged her harder than I had in months. We lawyered up. Our attorney, a calm but fiery woman named Martha, said she'd never seen such a grotesque abuse of HOA power. It's intimidation. She's betting you'll cave. But we didn't. We countersued. Claimed discrimination under the Americans with Disabilities Act. Brought forth the community guidelines and state protections. It wasn't just about a ramp anymore, it was about dignity. The court date was set. Karen insisted on representing the HOA herself, declaring she had a legal studies certificate from an online program. The judge approved it. That moment I saw the glint in her eyes, not fear but delight. She wanted this fight. She thought she'd win. As the court date approached, tension thickened. Riley had trouble sleeping. She didn't understand why she couldn't play in the yard without Karen driving by, slowly glaring. I found her crying one night, asking if she was the reason we were in trouble. No, sweetheart. You're the reason we're fighting. The week before trial, Karen filed for a protective order against me. Claimed I had threatened her safety and acted erratically. The judge rejected it, noting her lack of evidence, but it gave her ammo for the courtroom. The morning of the hearing, I dressed Riley in her favorite yellow sunflower dress. She clutched her stuffed dolphin, a gift from her physical therapist. My husband squeezed my hand. We entered the courthouse like soldiers heading to battle. Karen was already there. Perfectly pressed suit. Bright red lipstick. Clipboard. She didn't even glance at Riley. She stood confidently as proceedings began. Made snide remarks under her breath. When our lawyer presented photos of Riley's ramp, Karen objected, irrelevant to neighborhood aesthetics. The judge warned her. But she didn't stop. During a recess we stepped into the hallway. Riley wanted a juice box. My husband left to get one. That's when Karen approached us, unseen by the bailiff or guards. She leaned down and said to Riley, "You know, if your parents hadn't tried to fight me, none of this would be happening. You're just a prop to them." Before I could react, she reached into her oversized bag. What happened next would send shockwaves through every legal building in the state. It happened in a blur, but every frame of that moment is burned into my memory with crystal clarity. Karen's hand disappeared into her oversized crocodile print purse. I instinctively stepped forward, shielding Riley. My mother's intuition screamed louder than any courtroom etiquette ever could. And then, click, a small boxy black device emerged. My heart stopped. She wasn't bluffing. It wasn't pepper spray or a phone or a warning. It was a taser. With one fluid, practiced motion, Karen turned her wrist and pressed the trigger. The crackling buzz was deafening in the quiet marble corridor of the courthouse. In that split second before impact, I saw Riley's eyes widen in confusion. She didn't even have time to scream. The taser hit her side. Her little body jolted, arms stiffened, legs curled, then she collapsed from her chair to the cold tile floor like a rag doll. Time stopped. There was no sound except the fading buzz of the taser and my own scream tearing out of my throat like an animal's howl. People rushed in, law clerks, a security guard, a nearby attorney who'd been walking out of another courtroom. Karen stood frozen, taser still in hand. Her mouth hung open, almost proud. Then she finally said flatly, she lunged at me. I was defending myself. No one believed her. Not a soul. Riley lay on the floor convulsing, her dolphin plush sprawled beside her. Her dress had bunched up at the waist, and I saw a red welt where the taser had struck. I dropped to my knees, barely able to breathe as I cradled her head, trying to keep her calm and still. "You're okay, baby. You're okay. Mommy's here. Stay with me. You're safe." Paramedics were called. The courtroom emptied. Court staff ushered us into a side room while first responders tended to Riley. My husband returned mid-panic, juice box in hand, and when he saw the stretcher rolling out and our daughter lying on it unconscious, his scream matched mine. Karen was detained immediately. Not arrested yet, just detained. Apparently, the legal system takes a moment even when a woman tasers a disabled child in a federal courthouse. But cameras don't lie, and that hallway had two angled security feeds that captured everything. Every word. Every step. Every criminal second. I gave my statement through tears, clutching Riley's blanket in my lap while my husband sat in stunned silence beside me. Karen, meanwhile, was in a room across the hall demanding to speak to the court clerk to make a formal complaint about the judge's bias. Security footage was pulled that same afternoon. Court officers reviewed it behind closed doors. A marshal came out and said only one sentence to Karen: "You need to put your hands behind your back." That's when it hit her. The moment her arrogant mask cracked. For the first time since we'd moved into the neighborhood, she looked scared. Handcuffs clicked shut. Her lipstick smudged as she shouted that we were manipulating the court and that disabled people shouldn't be used as shields. She tried to invoke her HOA authority, then her legal certificate. Then she finally screamed that she knew people in the mayor's office. No one cared. She was booked for felony assault, use of a stun device on a minor, battery, and disorderly conduct in a federal building. Bail was denied due to escalating violent behavior. We would later learn that she'd been cautioned by police once before in a completely unrelated HOA incident. Something to do with threatening a landscaper, but those records were sealed. Not anymore. Riley was hospitalized for 2 days. The taser's effect was compounded by her spinal condition, and the trauma caused temporary regression in her physical therapy progress. She became jumpy, withdrawn. For the first time in years, she wouldn't speak to her therapist. She barely responded to us. At one point she whispered, "Did I do something wrong?" We told her over and over again, "You did nothing wrong." And we meant it. But the pain in her eyes wouldn't lift. As her mother, I wanted blood. But I knew what mattered now was the truth, and making sure no one else's child ever had to go through something like this. The story exploded. At first it was local news. HOA president uses taser on disabled girl in court. Then the regional channels picked it up. Then the national outlets. CNN. MSNBC. A headline in the New York Times read, "Community tyrant tasers child during court case over wheelchair ramp." Karen's mugshot was everywhere. Her smirk was gone, replaced by confusion and rage. Her charges were confirmed by the U.S. Attorney's Office, who decided to pursue federal assault charges because the incident occurred in a federal facility. But nothing shook the world more than what came next. 3 days after the attack, while Riley was still in the hospital and our phones hadn't stopped ringing from lawyers, media, and neighbors, our attorney Martha walked into the room and said, "There's something you should know." Apparently, a federal judicial ethics board had been alerted by the marshals after Karen's arraignment. What? Because Riley's mother was a sitting federal judge. Not me. My wife. My partner of 16 years, whom we'd all agreed should stay quiet during this process to avoid conflict of interest or any notion of judicial influence. She served under a different last name, her maiden name, and had been carefully avoiding public connection to this suit. We agreed early on that I would be the public-facing plaintiff not just for optics, but to avoid precisely this kind of weaponized drama. But the moment Karen tasered Riley on federal grounds, the veil dropped. Every branch of authority got involved. And Karen had no idea. She tasered the daughter of a federal judge, on government property, during an open legal proceeding. By the time the U.S. Marshals traced the connection, Karen was already facing federal charges, but now the case had a new layer. A dozen agencies began internal reviews, from courthouse security failures to HOA regulatory oversight. The next court hearing was even more surreal. Karen was wheeled in wearing a beige jail-issued jumpsuit. Gone was the blazer. Gone was the perfect hair. Her eyes scanned the courtroom until they landed on my wife, who sat silently, expressionless, in the second row beside Riley. Karen's mouth parted in slow horror. It was only then that she realized who Riley's other mother was. That the woman she had once insulted in a neighborhood meeting as an absentee spouse with a suspicious job title was Judge Eleanor Holt, one of the youngest women appointed to the federal bench in our district. And let me be clear, Eleanor didn't have to lift a single legal finger in this fight. The law was already stacked against Karen based on her own actions. But the media, and the public, latched onto the irony, the karma, the poetic justice of it all. Commentators called it one of the greatest real-life examples of abuser meets power. Karen's lawyer begged for a change of venue. Denied. Then they begged for a gag order. Denied. Every legal maneuver they attempted backfired. Meanwhile, Riley was slowly recovering. The hospital had her on light activity. Her therapists were working double time to help her regain emotional footing. She started drawing again, pictures of dolphins and stars and tiny smiling figures in wheelchairs. She didn't want to talk about Karen. She just wanted to go home and not be scared anymore. Community support surged. Neighbors who once stayed silent now lined our lawn with flowers, balloons, handmade cards. Someone installed solar lights around our ramp in the shape of a heart. Another built a wooden sign that read "Riley's Ramp, protected by the people." A local artist painted a mural of Riley, arms outstretched, wheelchair lifted into the clouds, surrounded by sunflowers. It was breathtaking. Karen's life unraveled with equal speed. Her husband filed for divorce. Her name was blacklisted from every HOA committee in the county. A class action lawsuit began forming from other homeowners she bullied over the years. Someone leaked videos of her berating landscapers, calling cops on a 14-year-old for skateboarding, screaming at an Amazon driver for unauthorized presence. The world saw what we'd been seeing all along, a tyrant cloaked in paperwork and privilege. And still, justice was only just beginning. The prosecution filed additional charges. Karen's taser was unlicensed. Her claims of self-defense were publicly debunked by security footage that showed Riley doing nothing but smiling before the attack. The court declared her a public threat. Bail was again denied. But more than any of that, Karen would now face a trial in front of the entire country. And her victim? A little girl with a wheelchair, a dolphin plush, and two fiercely determined moms. The courtroom was packed, not just with lawyers and reporters but neighbors, veterans, and disability advocates from around the country. Front and center sat Riley, flanked by her moms. She looked small in her custom wheelchair, a dolphin plush in her lap, dressed in a tiny judge's robe. But despite the fear in her eyes, she held her head high. Karen looked nothing like the woman who had once ruled the HOA with an iron fist. She sat pale, slouched, scribbling notes she'd never use. Her former swagger had vanished. Gone was the HOA tyrant. What remained was a woman unraveling under national scrutiny. The prosecution laid out their timeline. A year of harassment, the ramp dispute, the court confrontation, and the shocking taser assault on a disabled child. They presented surveillance footage, audio recordings, and witness testimony, including the marshal who tackled Karen seconds after the taser struck. Each piece of evidence landed like a hammer. The moment Riley screamed on tape, the courtroom fell into stunned silence. Jurors shifted. One dabbed tears. Karen's defense scrambled to control the damage. They blamed stress, cited provocation, claimed a taser malfunction. They even argued Riley wasn't visibly disabled enough to justify special protections, a move that infuriated the room and prompted the judge to slam her gavel for order. Then the prosecutor stood and addressed the jury directly. This woman tasered a disabled child in a courthouse. And she's asking you to see her as the victim? No further questions. After 6 days of testimony and just 3 hours of jury deliberation, the verdict was read. Guilty of felony assault with a weapon. Guilty of using a stun device on a minor. Guilty of battery. Guilty of disorderly conduct in a federal facility. Guilty of malicious harassment based on disability. Karen sat frozen, her mouth opening without sound. Her world collapsed in real time. Within days, the HOA disbanded completely, citing irreparable damage. Karen's own son, previously unknown to the public, posted a TikTok condemning her actions and apologizing to Riley. "She's always been like this," he said. "I wish I had spoken out sooner." Neighbors began coming forward with stories. A woman claimed Karen fined her $50 a week for wind chimes she deemed too spiritual. Another showed emails from Karen threatening to sue him for installing a little free library. As the story spread, lawmakers introduced the Riley Act, designed to limit HOA authority over accessibility changes and add serious penalties for HOA harassment targeting disabled people. It passed unanimously in committee and drew national support. Disability organizations called Riley a symbol of quiet resistance. Media outlets aired our story. We tried to shield her from the spotlight, but she stayed grounded. When asked how she felt about it all, she simply said, "I just want people to be kind." Sentencing day arrived a month later. The judge addressed Karen bluntly. "You abused your power, violated public trust, and committed violence against a defenseless child. You've shown no remorse. You are the architect of your own destruction." She was sentenced to 18 years in federal prison with no chance of parole for at least 12. No one cheered. Her own lawyers didn't look her in the eye as she was cuffed and led away. Outside, a crowd held signs. "Justice for Riley. HOA reform now. Kindness over control." And one that read, "You picked the wrong kid. You picked the wrong family." Later, when I asked Riley how she felt, she said, "I'm hungry." So we took her for pancakes. A year later, the ramp remains, freshly painted in rainbow hues. A plaque at the base reads, "In honor of Riley, who showed the world how to rise." The HOA was replaced by a transparent, community-led board. Karen's ornamental gravel lot is now a garden where kids play. Riley helps plant sunflowers. She's thriving in school, especially in art. And she just got a service dog named Scout. His vest says, Justice Pup. We still carry scars. But they no longer control us. We've learned that justice doesn't just come from courtrooms, it comes from compassion. From communities that refuse to let hate win. And from the quiet strength of a little girl in a wheelchair, who refused to be broken.